Hello, I'm Jenny Kiffmeyer, Chief Operating Officer of the Retirement Learning Center. Welcome to our regular segment on Case of the Week. This week's case relates to defining an employee versus an independent contractor for retirement plan coverage purposes. As a reminder, these are real-life cases drawn from calls to our consultants on the resource desk from financial professionals all over the country. Our question today is, do the final Department of Labor regulations defining employee versus independent contractor affect who can participate in retirement plans? The answer is, they may. Whether a worker is an employee or independent contractor is an important determination that has several implications for employers, including for labor standards, tax purposes, and retirement plan coverage. The Department of Labor has issued new regulations effective March 11th of 2024, addressing how to analyze whether a worker is an employee or an independent contractor under the Fair Labor Standards Act, or FLSA. While the final rule does not directly apply to ERISA, if a worker is a quote-unquote an employee and not an independent contractor under the FLSA standard, then he or she may be eligible to participate in any employer-sponsored retirement plan if he or she meets eligibility requirements. Conversely, if a worker is an independent contractor, then he or she may be able to establish a retirement plan based on self-employment income. Now, whether a worker is an employee or an independent contractor under the new FLSA standard is determined by applying the six-part economic realities test. The six factors are the opportunity a worker might have to affect profit or loss. Number two, the financial stake and nature of any resources a worker has invested in the work. Number three, the degree of performance of work relationship. Number four, the degree of control an employer has over the person's work. Number five, whether the work the person does is essential to the employer's business. And six, a factor regarding the worker's skill and initiative. Employers must look at the entire working relationship to decide whether a worker is an employee or an independent contractor. The final rule provides detailed guidance regarding the application of each of the six factors. No factor or set of factors among this list of six has a predetermined weight, and additional factors may be relevant as well. Keep in mind that this new rule is specific to FLSA purposes, including wages, the fair treatment of employees, and child labor laws, among other things. The IRS, for tax purposes, has a separate employee standard. The IRS uses a 20-part test, used to, I should say, but it has since reduced it to a 3-part test to determine employee or independent contractor status. The three factors are financial control, behavioral control, and the nature of the working relationship. You can see there is overlap between the FSLA standard and the IRS standard. When it comes to plan coverage purposes, ERISA imposes a 2-part test that an individual must meet to qualify as a plan participant. First, the individual must be an employee. Second, the individual must be eligible to receive benefits under the plan according to the terms of the plan document. For the first prong, we need a definition of employee. The second prong underscores the importance of reviewing plan document language to see how the terms employee and participant are defined. In application, some courts have looked to the IRS standard to set the term employee for plan coverage purposes. It is possible that courts could apply the new FLSA definition of employee for plan coverage purposes. I'll wrap this up by saying that determining whether a worker is an employee or an independent contractor, particularly for retirement plan coverage purposes, can be tricky. The DOL has a new FLSA employee standard. There's also the IRS definition of employee for tax purposes. Both of these standards may impact whether a worker is an employee that should be covered under employer-sponsored retirement plan. As a financial advisor who works with plan sponsors, always look to the plan document for guidance. If you are looking for a more in-depth written version of this case, you can find it on our website at retirementlc.com. Thank you.